say that even though that you're complying with the law and that is what we require, it is our policy to have open meetings, and in order to have a open meeting that is conducive to the community, to your organization, it would be one that you need to get those agendas out earlier, allow people to participate, and then you'll have a better organization for it.
Mr. Kimball.
Well, the law about regular meetings does not specify a minimum time for notice. However, the law about special meetings does. It says the notice shall be calculated so that it shall be received at least 24 hours before the special meeting. So I think if special meetings require 24 hours notice, then regular meetings certainly require more than 4 hours of notice. And that's what I'd tell them if they asked me.
Thank you. Mr. Conway.
What he said. Now, I was going to say that exact same thing. Again, as a potential attorney general, you don't want to comment on something that Shannon, with the excellent question, may be bringing to our attention. However, it makes little sense to say that you're supposed to post regularly scheduled meetings of a public agency, and that you're supposed to notify certain members of the press who regularly ask for your schedules, and you're supposed to make every effort to post emergency or special meetings within 24 hours. So it certainly does not seem, in my estimation, to comport with the spirit of the law, and I would just leave it at that.
Mr. Bullock.
Well, I agree with just about everybody here on this issue, but I think we should point out that in a meeting like this, an open meeting, the agenda is probably one of the most important parts of the whole meeting, because you have to know what the agenda is going to be in order to be able to formulate whatever position you might have at a meeting. Especially if it's open for public comment, the agenda becomes very, very important. So while the Attorney General, because it's a quasi-judicial office in this particular instance, could not make an opinion ahead of time, it would be to everyone's advantage to understand the importance of an agenda and to make that agenda available as early as possible.
Thank you. Mr. Coleman will have this question first. In the 2006 session of the General Assembly, legislation was proposed that would allow communication to and from legislators to be kept private. Should emails, telephone records, letters, and other communication to and from legislators be unavailable to the public? Mr. Coleman.
Well, that's a tough one. And I was trying to think of, in reviewing the laws, I'm not sure if our open records applies to legislative proceedings, but let's say it does. And I would think that there has to be, I think communications with a legislator and his constituents should be one that is a matter of personal information. It depends on the matter. That way we could have more, we would influence more communication with particular constituents with regard to their problems. So I would not encourage a statutory requirement that would require individual letters from a constituent to the legislator to be disclosed.
Mr. Kimball.
Well, I agree with that. I think if the one party, not the legislator, wants to make it public, it certainly can. But I don't think we should mistake open records and open meetings laws for just a complete examination of everything that every public official does every day. That's a little ridiculous. I mean, what we're trying to do is find out what their acts are and what their official statements and proceedings amount to and records, not their even quasi-private communications.
Mr. Larson.
What we have here is a balancing of interest that, in my mind, doesn't move toward disclosure. I'd like our legislators to have a chance to freely discuss things. Now, there's times that they may say things that probably should be revealed. They're bad thoughts or whatever, but in the balance of things, it's my impression that freedom to discuss things is more important in a legislative body than to require disclosure of every past thought. And I wonder what's going to happen to appeals in the future if that was the law, if suddenly they try to trace legislative history and require the emails of the various legislatures to be revealed as showing legislative intent. Sorry, in that balance, I think non-disclosure is better.
Mr. Bullock?
Well, I believe that the communication should be open. I believe that the public should have a right to know if someone is writing a letter, for instance, that may have political overtones, that may be against the public interest in order to influence legislation that may not be in the public interest. I think there is no legislature confidentiality in a situation like that. It should not be. So I would favor opening that, keeping open that record between a legislator and a constituent.
Mr. Conway?
Bob, I'm surprised to hear you say that because, Judy, if I'm not mistaken, there's an opinion of the Attorney General or decision that's exactly on point. Letters or correspondence from a legislator to a constituent are not considered open records within the meaning of the Act. That's something that's long been decided by the office. Those records are not deemed to be final agency action, and they're not deemed to be the type of permanent government record that's subject to disclosure. And I would assume that if you have an established decision that says that for a letter, the same thing would go for an email. Email is the preferred communication